You're driving down a street, maybe looking at potential properties for a client, and you see a seemingly empty lot. Or maybe you're reviewing a listing for a fixer-upper, with expansion potential. You might think, what could be built here, or what can my client actually do with this property? It feels like it should be straightforward, right? But behind every piece of land, every potential project, there's this complex, often invisible web of rules, regulations, and government powers dictating exactly what's possible.
It's so true. Think of it less like a blank canvas and more like a detailed, sometimes frustrating master blueprint. Or maybe even an invisible hand, constantly guiding and, well, limiting how properties can be used and developed. This isn't just theoretical stuff buried in textbooks. It directly impacts property value, whether a client's dream project is even feasible, and critically, the rights and responsibilities of property owners.
And for you, the aspiring California real estate professional navigating the Golden State's unique market, understanding this blueprint isn't just helpful, it's absolutely essential. Yes, it's definitely on the exam, and you have to know it to pass. But way beyond that, this knowledge is fundamental to advising your clients wisely, helping them spot potential issues before they become costly nightmares.
Yeah, avoiding the surprises down the road.
Exactly. And practicing real estate with genuine integrity is how you become that trusted guide, helping them move forward confidently in a landscape filled with these hidden forces.
Our mission in this deep dive is to take the sources you've shared, articles, county documents, legal explainers, and extract the absolute crucial nuggets. We're going to unpack the foundational rules of planning and zoning, look at the government's significant, sometimes controversial power of eminent domain, delve into California's critical environmental regulations like CEQA, and explore how we factor in the very real constraints imposed by natural hazards.
Okay, let's start laying the foundation of this master blueprint. Where do we begin?
We begin at the local level, with planning and zoning. At its core, planning is the process local governments use to strategically think about and shape how their communities will grow and evolve. The Nashville Planning Commission's mission statement actually captures this pretty well. They aim to guide development towards a more socially, economically, and environmentally sustainable place.
Sustainable, meaning preserving assets, using infrastructure efficiently.
Right. And maintaining neighborhood character, providing choices for residents. It's about looking ahead.
So it's a forward-looking process, thinking about the big picture for the community, not just reacting to individual projects.
Exactly. It's the proactive vision. And the key document that lays out this vision for a city or county is the general plan. State law requires these plans in California. The Contra Costa County General Plan document you shared is a great example. These plans have to include a statement of development policies, diagrams, or maps illustrating these policies, and detailed text setting forth objectives, principles, standards, and proposals for the community's future.
Policies, objectives, principles, standards. That covers a lot. What specific areas are typically addressed in a California general plan?
They cover a wide range, reflecting the complexity of a modern community. The Contra Costa example shows typical elements like land use, which dictates how different areas can be used, transportation circulation, focusing on how people and goods move, housing, addressing the community's housing needs.
Essential services too, right? Like water, schools.
Absolutely. Public facility services covers essential infrastructure like water, sewer, schools, police, fire. Then there's conservation, looking at protecting natural resources, agriculture, and open space. And open space itself, often dealing with preservation goals, scenic areas, and historic or cultural resources.
And the maps that go with these plans, how specific are they? Can you look at a general plan map and know exactly what you can build on a single parcel?
That's a fascinating point, and one where there's some debate even within planning. State law generally says general plan maps don't need the same level of detail as, say, a specific zoning map. However, they should be detailed enough so that someone reviewing the map, along with the relevant text in the plan, can reach the same general conclusion about the appropriate use of any given parcel at a specific stage of development.
Okay, so it's more about the intent for the area.
Exactly. It's about providing clear guidance on the intent and policy for an area, even if it's not parcel-specific zoning. Directional rather than absolute.
Got it. And you mentioned local measures can heavily influence these plans.
Absolutely, and this is a key California-specific point. The Contra Costa General Plan, for example, explicitly references Measure C from 1988 and 1990. These local ballot measures established specific policies and principles that became foundational to the county's plan, particularly impacting growth management and land use decisions for decades.
Measure C had a pretty famous, or perhaps infamous, depending on your perspective, standard about land preservation.
It did, and this is a critical nugget if you're dealing with property in Contra Costa County. Measure C 1990 established the 6535 Land Preservation Standard. The standard is directly incorporated into the general plan and mandates that development countywide be limited to no more than 35% of the total land area.
35%.
Not more than that. With at least 65% preserved for agriculture, open space, wetlands, parks, and similar non-urban uses. Imagine that a county with a legal mandate that over half its land must remain undeveloped open space or agriculture. That's a massive constraint.
Wow. A 65-35 split legally mandated. That fundamentally changes how you'd evaluate potential development sites there. So how would an agent actually go about using a general plan to understand a property's potential or limitations?
It requires a bit of detective work, but it's essential. The Contra Costa source gives a suggested sequence, calling it the bare minimum for a rural property. You'd first check if it is in a rural area, then consult the public facility services element to see if the policy allows it to be served by public water, sewer, and other utilities.
Because rural policies often discourage extending those extensive lines.
Often, yes. Then you definitely dive into the land use and open space elements to see how the property fits into the county's overall land use map and, crucially, how that 6535 standard might apply or influence policy in that specific area. And if the property is near something like a highway, you'd look at the noise element to see if it's within a mapped noise contour and if noise mitigation policies are required for development.
So you can't just look up a single zone. You have to understand the confluence of policies across different elements of the plan that might impact a property.
Precisely. The general plan is the high-level policy document. From that vision, we get more specific rules, particularly for dividing land into smaller parcels. That's where subdivision regulations come in.
Subdivision regulations splitting a large piece of land into multiple lots for houses or other development.
Exactly. These regulations govern that process. Their purpose, echoing the planning goals from the Nashville source, is to guide growth, ensure infrastructure is used efficiently, preserve neighborhood character, and provide choices. They ensure that when you create new parcels, they fit into the existing community structure and have the necessary roads, utilities, and public spaces.
What's the typical process someone goes through to subdivide land?
It generally follows a standard progression, like the one outlined for Nashville. You start with a concept plan to get initial feedback.
Kind of like a rough sketch.
Sort of, yeah. Then move to a detailed final site plan showing everything from lot lines to utilities, roads, and drainage. The final step is the final plat, which is the legal map recorded with the county.
And what are some of the key things these regulations dictate?
A lot. Street design is a big one, specifying whether roads must be public or private, setting requirements for block lengths and perimeters, emphasizing connectivity, and guiding the appropriate use of features like cul-de-sacs versus interconnected streets, especially for infill development.
Easements are often part of subdivision, aren't they?
Absolutely. Subdivision regulations often require various types of easements. The Nashville source mentions pedestrian access easements to ensure walkability, greenway conservation easements along waterways consistent with the general plan.
Scenic easements, too, to protect views.
Yes, even scenic easements to protect important views.
I also saw a mention of alleys in the regulations you shared. Are those common?
Alleys are an interesting design element that subdivision rules can govern. They can be required in commercial and industrial areas. In residential areas, they're often considered appropriate because they can improve access to lots, allow garages to be located off the alley rather than facing the main street, which changes the streetscape, reduce the number of driveways crossing sidewalks, and potentially minimize the need for extensive grading or disturbance on the main road frontage.
And public land dedication is often part of this, like giving land for parks or roads.
Yes, dedication requirements are common. As part of getting subdivision approval, a developer might be required to dedicate land for public right-of-way for streets, or land for public parks or greenways, especially if the subdivision benefits from or impacts those public amenities.
And how do the regulations ensure all the required infrastructure, like roads and utilities, actually gets built? I mean, you don't want houses without streets.
Definitely not. That's where improvements and performance bonds come in. The applicant is responsible for constructing all the required infrastructure, streets, sidewalks, water lines, sewer lines, drainage. To guarantee they complete this work according to the approved plans and standards, they are often required to post a performance bond or other form of security. If they fail to build the infrastructure, the local government can use the bond money to finish the job.
Okay, that makes sense, a safety net. And the term critical lots appeared in the subdivision source as well. What are those?
Critical lots are specific lots created during the subdivision process that are designated because they contain features that make construction feasibility questionable. The Nashville source mentions natural slopes of 20% or greater, lots containing natural floodplain, or other features that pose significant challenges to building.
So like a really steep hill or land in a flood zone.
Exactly. And the consequence of a lot being designated critical, before a building permit can be issued for a critical lot, it typically requires the submission and approval of a critical lot plan. This plan has to demonstrate how the proposed development will overcome or address the feasibility challenges posed by the critical feature, detailing grading, retaining walls, drainage solutions, tree preservation, etc.
Okay, so subdivision regulations are the detailed rules for splitting land, ensuring infrastructure, addressing public needs, and flagging tricky sites like critical lots. Now, let's zoom in even further. What about changing the specific use allowed on a property after it's already been zoned and potentially subdivided? That's where zoning variances and changes come into play, right?
Exactly. This is about getting permission to do something on a specific property that the existing zoning rules wouldn't normally allow. A zoning variance is official permission to deviate from the strict letter of the zoning requirements for that particular property.
Why would someone need a variance? Can't they just follow the rules? I mean, aren't the rules there for a reason?
Well, yes, but the purpose of variances is to provide a limited degree of flexibility within the rigid framework of zoning, but without undermining the overall intent of the zoning plan for the neighborhood. Zoning rules are general, applied broadly. Sometimes a specific property has unique physical characteristics like an unusual shape, steep topography, or other site conditions that create a unique hardship or practical difficulty if the owner had to strictly adhere to the standard zoning setbacks, height limits, or lot coverage rules. The variance offers a way to relieve that specific unique hardship.
Ah, so it's not just about wanting to build something bigger or easier. It has to be tied to the property itself.
Absolutely not just wanting something different. And this is a key point. Variances are not easy to get and are not granted lightly. They require thorough examination by the local government and careful consideration of the impact on the surrounding community and the integrity of the zoning plan. The applicant has a significant burden of proof. They must demonstrate that their need for a variance stems from a unique hardship related to the physical characteristics of their specific property.
Okay, distinguishing it from just general inconvenience that maybe everyone in the zone faces.
Precisely. It's not about personal financial hardship or inconvenience unrelated to the land itself.
And are there different kinds of variances?
Yes, the source mentions use variances as a significant type. This is perhaps the hardest variance to get. A use variance permits a property to be used in a way that is not typically allowed in that zoning district at all, like seeking permission to operate a small commercial business in a residential zone, or allowing multifamily units in an area zoned exclusively for single-family homes.
That sounds like it would be a huge hurdle. Why are use variances so difficult to get?
Because they represent a fundamental departure from the established character and purpose of the zoning district. Securing a use variance involves extremely stringent scrutiny. The property owner must demonstrate a tangible hardship directly related to the property's physical characteristics and the current zoning restrictions that prevents them from realizing a reasonable economic return on their investment under any of the uses currently permitted by the zoning.
Wow, so they basically have to prove the property is almost unusable as zoned.
Pretty much. It's a very high bar, intended for rare circumstances where strict adherence to the zone makes the property practically unusable for its intended purpose.
Okay, let's pause here for a moment and put on our think like an agent hats. Imagine you're working with a client who's fallen in love with a rural property, maybe a few acres outside of town. They tell you excitedly, we want to build a main house, a smaller second unit for grandma, and eventually maybe a workshop where I can run my woodworking business.
Right away, your internal agent alarm should go off. Ding, ding, ding. You've just heard potential flags related to subdivision, zoning density, and allowed uses. You need to look beyond the client's excitement and check that master blueprint. Is the property already subdivided into buildable lots? Does the current zoning allow for a second unit? An accessory dwelling unit or ADU, which California law has made easier, but there are still local rules. And crucially, does the zoning allow any commercial activity, like a workshop, or is it strictly residential?
And if the zoning is large lot residential only, with no commercial allowed, and the property hasn't been split yet, what's your role then?
Your role isn't to crush their dreams, but to guide them through the reality of the regulations. You explain that based on the current zoning, the workshop isn't permitted, and creating that second unit, or splitting the land, requires navigating the local subdivision and potentially zoning processes. You'd have to discuss the possibility of seeking a use variance for the workshop, explaining how difficult that is, and the kind of unique hardship they'd have to prove related to the land, not just their business plan.
Right, that hardship point again.
Exactly. You'd also need to discuss the subdivision process and whether the property size and current zoning even allow for splitting it into smaller parcels as they envisioned.
Okay, different scenario. What if that rural property has access only via a narrow dirt road that crosses a neighbor's land?
That brings up access, easements, and subdivision requirements again. Subdivision regulations often have standards for street width, construction, and legal access. Does that dirt road meet the requirements? Is there a legal recorded easement providing access to your client's parcel across the neighbor's land? That's huge. If not, or if the road needs upgrading for subdivision or development, could that require a variance from the road standards, or would a formal easement need to be negotiated and recorded? You need to know these regulations exist to even ask the right questions and advise your client that this isn't just a simple matter of using a path, it has regulatory implications.
So, knowing these planning, subdivision, and zoning rules helps you identify potential problems early, manage client expectations, and guide them toward understanding the steps needed, whether it's a variance application, a subdivision process, or maybe seeking legal advice on access.
Exactly. It positions you as a knowledgeable ethical guide, helping them navigate the regulatory landscape. Now, let's shift gears from local planning and zoning rules to a significant power held by the government that can override private property rights entirely eminent domain.
Eminent domain, that's when the government can take private property for public use, right? Even if the owner doesn't want to sell.
That's the core concept. Investopedia defines eminent domain as the power of the government, federal, state, or local, to take private property and put it to public use, provided they pay just compensation to the owner.
Where does this power come from in the United States? Is it just assumed?
No, it's rooted in the U.S. Constitution, specifically the Fifth Amendment, which contains the Takings Clause. It reads, "Nor shall private property be taken for public use without just compensation." The National Constitution Center highlights this as the foundational basis for the power.
So it's constitutional power, but it's not unlimited. It comes with two big conditions: public use and just compensation. What's the principle behind allowing the government this power at all? Seems pretty drastic.
The underlying principle, articulated by the Supreme Court in cases like Armstrong v. United States, is fundamentally about fairness. It prevents the government from forcing just a few people to bear the cost of something that benefits the entire public. If the government needs private land for a highway or a school, projects that serve the public as a whole, it shouldn't bankrupt the individual property owner whose land is needed. The requirement for just compensation helps ensure that burden is shared, or at least compensated for, by the public that benefits.
Okay, fairness for the individual when their property is needed for the collective good. How is public use generally interpreted? Can they take land for anything?
Well, the National Constitution Center points out that there's general agreement among courts and scholars that the property must genuinely be taken for public use. There's consensus that this power cannot be used simply to take property from person A and give it to person B solely for person B's private economic benefit. Now, the Kelo v. City of New London case in the early 2000s brought a lot of debate about what constitutes public use when economic development is involved.
Right, I remember that case, taking homes for a private development project.
Exactly. It was very controversial. But the core principle remains that it must benefit the public broadly, not just a private individual or entity.
And what does just compensation mean in practice? What does the owner actually get?
Just compensation is designed to make the property owner whole. It means the owner must receive, at a minimum, the property's fair market value. This isn't just the value based on its current use, but often it's value based on its best alternative use, assuming the property was available on the open market, independent of the government's need for it.
Independent of the government's need.
Mm-hmm.
So they can't lowball based on the fact that they need it.
Precisely. The Investopedia source specifies this independence. Compensation is typically paid in cash, but the National Constitution Center notes it could potentially involve reciprocal benefits if the government action increases the value of the owner's retained land. For example, if only part of the land is taken for a road that increases the value of the remaining part.
Fair market value, based on best use, ignoring the government's need that seems key to protecting the owner. Are there different ways the government might take property under this power? Is it always the whole thing?
No, not always. The Investopedia source mentions different forms. It can be the seizure of the entire property or just a partial taking, like needing a strip of land for a road widening. There's also the concept of a temporary taking.
A temporary taking, like for a limited time, how does that work?
Precisely. A temporary taking means the government needs the property for a set duration. Investopedia mentions this is often seen by owners as akin to a forced lease. A common example is needing a temporary construction easement on part of a property while public infrastructure is being built nearby. Compensation for temporary takings is often based on the rental value of the land for that period.
Interesting. So it's not always a permanent loss. What recourse does a property owner have if they believe the government has unfairly used eminent domain or hasn't offered just compensation? What if they just say no?
Well, they can't ultimately just say no if the taking meets the legal requirements. But if they believe the government has acted improperly, that's where inverse condemnation comes in. Investopedia explains this occurs when a property owner believes the government has taken their property or burdened it so severely that it amounts to a taking. But the government hasn't initiated formal eminent domain proceedings or offered compensation. In these cases, the property owner might initiate a lawsuit against the government, arguing that a taking has occurred and they are due just compensation.
Okay, so the owner sues the government, saying, "You took my property without paying." Now, this leads us to a really complex and often controversial area. When government regulation starts to feel like a taking, even without formal seizure.
This is the tricky world of regulatory takings. It's a huge challenge for courts and legal scholars to define precisely when a government regulation like a stringent environmental rule or a development restriction burdens private property so heavily that it's functionally equivalent to a taking and requires compensation under the Fifth Amendment.
And related to that are exactions, right? That sounds like a legal term.
Yes. Exactions happen when a government agency conditions the approval of a development permit on the property owner dedicating some property interest, either land itself or money, to the government. The classic example is being told you can get your building permit if you dedicate a portion of your land for a public street widening or maybe contribute to a park fund.
So the government isn't taking the land outright via eminent domain, but they're conditioning the approval the owner needs on getting something from the owner, kind of like leverage.
Exactly. And the Supreme Court has put significant scrutiny on exactions, particularly in cases like Nolan v. California Coastal Commission back in 1987. The court established tests that these conditions must meet to be constitutional. First, there must be a logical nexus or connection between the required exaction, what the government is asking for, and the reason the government could legitimately deny the permit in the first place.
Okay, so the demand has to relate to the problem the project creates.
Yes. And second, building on Nolan and further clarified in Dolan v. City of Tigard, the exaction must be roughly proportional to the projected impacts of the proposed development. It can't be excessive.
Nexus and rough proportionality. So the demand for the land or money has to directly relate to the problems the project would create, and it can't be excessive relative to those impacts.
Precisely. These nexus and rough proportionality tests are the practical nuggets for an agent or property owner to recognize potential issues. As the National Constitution Center excerpts show, some views, like Richard Epstein's, argue that without this strict scrutiny, exactions can start to look like illegitimate leveraging of government power.
Like extortion.
Well, resembling corruption or extortion, potentially, if they're not tightly tied to mitigating the project's specific negative effects. Eduardo Peñalver highlights the difficulty, but acknowledges the Armstrong principle not forcing one person to bear a public burden seems relevant here too.
It's clearly a highly litigated and debated area, which the existence of empirical studies on eminent domain settlements, like the one mentioned for NYC, underscores. These aren't just theoretical legal concepts. They have real-world consequences.
Absolutely. Which brings us back to our role as agents, our ethical compass, if you will.
Right. What do you do if you're working with a client whose property is rumored to be in the path of a future freeway expansion? Or if a client is proposing a development that triggers significant requirements for dedications or fees from the local agency?
Your ethical duty is to be informed enough to recognize the potential issue. You're not giving legal advice that's for attorneys. Always refer them. But you must know enough about eminent domain and exactions to be able to say to your client, hey, this property could be impacted by future public projects and you should look into that. Or these conditions the city is putting on your permit, they seem significant, and you might want to have an attorney review whether they meet the legal tests for exactions.
So it's about giving them a heads up.
Exactly. It's about alerting them to potential impacts on their property rights and guiding them to the appropriate experts to protect themselves and understand their rights to just compensation or challenge unreasonable conditions.
It's about being proactive and empowering your client with knowledge and resources, ensuring they're not blindsided by government powers or regulatory demands.
Absolutely. Moving from the government's power to take property or condition development, let's dive into a major regulatory force that profoundly shapes land use here in California: environmental law, specifically CEQA.
CEQA, the California Environmental Quality Act. You really can't avoid this one if you're working in real estate development or significant property changes in this state, can you?
You really cannot. CEQA is California's foundational environmental statute. Its primary purpose, according to CalRecycle, is informational. It's designed to ensure that public agencies, when considering approval for a project, and the public are fully informed about the potentially significant environmental effects of that project.
So it's about revealing the environmental impact, making sure everyone knows what could happen.
Yes, and crucially, it also requires identifying ways to minimize those significant effects and exploring reasonable alternatives to the project that could avoid or reduce those impacts. It's about informed decision-making and mitigation.
What's the general flow of a CEQA review? It sounds complicated.
It can be. The CalRecycle source outlines the typical process. It starts with the lead agency, that's the government agency, with primary approval authority doing a preliminary review to see if CEQA applies at all. If it does, they conduct an initial study to determine if the project might have significant environmental effects. Based on the initial study, the agency makes a decision about what level of review is needed next.
And what are the main outcomes or documents from that initial study? What happens after that?
Okay. If the initial study finds no substantial evidence that the project will have a significant environmental effect, the agency prepares a negative declaration, ND. Basically, nothing to see here. If the initial study finds that there could be significant effects, but revisions to the project or specific mitigation measures can be incorporated to avoid or reduce those effects to a point where they are clearly not significant, then a mitigated negative declaration, MND, is prepared.
So MND means potential problems solved by changes. They tweak the project.
Right. And if an MND is adopted, the lead agency must adopt a program to monitor or report on those mitigation measures to ensure they're actually implemented. They have to follow through. Now, if the initial study finds that the project will or could have significant environmental effects that cannot be avoided or fully mitigated, then the most complex document is required, an environmental impact report. EIR.
The full EIR, that sounds like the heavy hitter. What does that involve?
An EIR is a detailed, comprehensive informational document. It analyzes the significant environmental effects, explores ways to minimize them, and describes and evaluates reasonable alternatives to the project, including a no-project alternative. EIRs can be very lengthy, very expensive, and very time-consuming to prepare.
Can an EIR ever be updated without starting from scratch as small changes are made to the project later?
Yes, the source mentions that if there are only minor additions or changes to a project that's already had an EIR, a supplement to the EIR can be prepared instead of a full subsequent EIR, provided certain conditions are met. Save some time and money.
And I read that sometimes a general plan can function as an EIR. How does that work?
Correct. A general plan can be structured to serve as an EIR for the policies and proposals contained within it, as long as it covers all the points required in a standard EIR and is organized clearly to demonstrate this. If a general plan is used this way, it also must be submitted to the state clearinghouse for review.
It sounds like CEQA is a massive process. Are all projects subject to this level of review, like even putting up a small shed?
Thankfully, no. Not every project requires a full CEQA analysis. There are statutory exemptions, which are classes of projects the state legislature has specifically exempted. And there are categorical exemptions, which apply to types of projects the Secretary for Resources has determined not to ordinarily have a significant environmental effect. These often cover minor construction, small alterations, or maintenance activities. Like your shed example, maybe.
Okay, categorical exemptions sound like a common path for smaller projects. But is it true there are exceptions to these exemptions? This seems like a critical area, maybe a bit of a trap.
This is arguably one of the most important nuggets about CQA for a California agent, and the SCAG source highlights it heavily. Yes, absolutely. Even if a project looks like it falls into a categorically exempt class, it might not be exempt if one of the exceptions applies, as outlined in CEQA Guidelines Section 1P300.2. If an exception applies, that project needs further environmental review, potentially requiring an initial study, MND, or even an EIR, even if it's just a small structure.
That feels counterintuitive.
Yeah.
Exempt, but maybe not. What kind of things are these exceptions? What red flags should an agent be looking for?
The STAG checklist provides crucial guidance here. One major exception is location. Many categorical exemptions, like those for small new construction, Class 3, minor land alterations, Class 4, or accessory structures, Class 11, do not apply if the project is located in a particularly sensitive environment.
Like near a wetland or endangered species habitat.
Exactly. Or might impact a designated environmental resource of hazardous or critical concern. So building a small shed might be exempt in one location, but not if it's right next to something protected.
That makes sense. Location matters. What else is on that red flag checklist from SCAG?
It includes things like whether the project involves new stationary noise sources, less common for small residential, but think loud mechanical equipment or significant changes to the roadway network beyond just basic site access. A big one for agents is whether the site is adequately served by utilities and public services, water, wastewater, electricity, gas, solid waste, stormwater drainage.
So even a small project might trigger review if it needs, say, a new septic system in a tricky area.
Potentially, yes. If you're in a rural area, this means checking if a well and septic system are code compliant and adequate. Inadequate service could be a red flag for potential environmental issues or required infrastructure upgrades triggering review.
So just because it's a small project doesn't mean it gets a pass if the infrastructure isn't there. Anything else?
Yes, others include projects creating new sources of air pollution or greenhouse gas emissions again, more relevant for industrial than a typical house, or changes in site drainage that standard best management practices can't handle. Also, aesthetic impacts like substantial new light or glare that degrades the character of the surrounding area. And checking if the site contains agricultural land or forested land, especially important farmland as mapped by the California Geological Survey, this can trigger review even for minor changes.
That SAG checklist is a treasure trove of potential CEQA headaches, even for projects that seem simple on the surface. It sounds like knowing those exceptions is as important as knowing the exemptions themselves.
Absolutely critical. And remember, CEQA is also fundamentally about public information and participation. It's not just for the agencies.
How does the public get involved? Where do they find this information?
The CalRecycle source explains that CEQA documents and information are usually available on the lead agency's website, at their offices, or the local county clerk. The State Clearinghouse's CQNet database is another key resource for state-level projects. The public has the right to review documents, submit comments during designated public comment periods.
How long are those comment periods usually?
Typically 30 days minimum for NDS MNDs, though it can sometimes be shorter if the State Clearinghouse approves, and the public can attend public meetings or hearings on the project.
And once the agency makes a final decision, like approving a project with an MND, what happens then?
They file a Notice of Determination, or NOD. Filing the NOD is crucial because it starts a clock, a 30-day statute of limitations for anyone who wants to file a lawsuit challenging the project's approval under AEQA. If the agency fails to file an NOD, the statute of limitations is much longer, 180 days. NODs for local projects go to the county clerk. Those involving state agencies also go to the State Clearinghouse.
This all feels very California-specific. Is this truly a CA corner topic? You don't see this level of review everywhere.
Oh, it absolutely is. While other states have environmental review laws, CEQA is uniquely California's system. Its scope, its process, the emphasis on alternatives and mitigation, the exceptions, it's very specific. The resources we've mentioned, CalRecycle, the State Clearinghouse, the CGS maps, the SAG checklist points, are all California-specific tools and regulations. For any agent working here, mastering CEQA, especially understanding when those crucial exceptions to exemptions apply, is non-negotiable. It's a complex layer unique to our state that profoundly impacts development feasibility and timelines.
Let's run another think like an agent scenario using CEQA. A client is buying a small commercial building built in the 1950s on a downtown infill lot. They plan a significant renovation and expansion, adding a second story and changing the use slightly. They assume it's just a building permit issue. Pretty straightforward.
Your agent brain should immediately think CEQA. even though its renovation expansion on an infill lot is the project significantly larger. Does it involve changing drainage patterns? Is it introducing substantial new mechanical equipment that might be a noise source? While many infill projects are streamlined or might qualify for exemptions, using that SCAG checklist internally helps you identify if there are any potential exceptions that might make it not categorically exempt. Could the expansion trigger requirements for stormwater treatment that change site drainage significantly? Could the new use or expansion introduce unforeseen impacts that weren't considered in the original zoning or previous approvals?
So you'd explain to the client that even for renovation expansion, the city's approval process could involve environmental review under CEQA, depending on the specifics. You'd mention the initial study process and the potential for an ND, MND, which might require specific changes to the project design or maybe even an EIR if the impacts are significant.
Exactly. You're not performing the CEQA analysis yourself, of course, but you're spotting the potential for it, managing expectations about timeline and complexity, and flagging issues like potentially needing utility upgrades or managing site drainage that might trigger further review based on those exceptions. It's about guiding them through the process and the kinds of questions they might face.
CEQA truly is one of the most detailed parts of the California blueprint. It adds layers of complexity you just have to anticipate. And speaking of the blueprint, the physical environment itself poses some non-negotiable constraints, especially with natural hazards. The land fights back sometimes.
The environment definitely has its own say in land use, particularly here in California. This falls under hazard mitigation planning. FEMA defines its purpose as reducing the loss of life and property by lessening the impact of disasters like floods, earthquakes, and fires. It involves communities identifying their risks and vulnerabilities and planning actions to reduce those impacts. Local governments integrate this into their broader planning documents and update their plans every 5 years.
So communities are trying to plan ahead for natural disasters. As an agent, how do I figure out the specific hazard risks for a property I'm looking at for a client?
Flood hazards are a major one, and the official tool for identifying them are the FEMA flood maps, or flood insurance rate maps, firms. These maps delineate special flood hazard areas and flood zones, which are critical for determining flood insurance requirements under the National Flood Insurance Program, the NFIP.
And different zones mean different risk levels and requirements, like some areas are worse than others.
Precisely. Knowing the flood zone is key. Zone AE, for example, is considered a high-risk area, meaning properties there generally require mandatory flood insurance if they have a federally backed mortgage, and must meet specific floodplain management standards for any new construction or substantial improvement. Building codes might be stricter there, too.
How easy is it to access these FEMA maps? Are they online?
FEMA is in the process of updating many maps through its map modernization program. While digital maps are becoming more widespread, the Cal OES My Hazards source notes that complete digital information might not be available for every single county in California yet, so sometimes you still need to check with the local planning department.
But California has its own readily accessible tool for checking various hazards, right? Something easier to start with.
Yes, and this is a great adapt and connect tool for you as an agent. The Cal OES My Hazards tool is a public-facing online resource specifically for California. You can type in an address, city, or zip code, or click on a map, and it will show you potential hazards identified for that area: earthquake, flood, fire, even tsunami risks in coastal areas. It also provides links to information on how to reduce those risks. It's an excellent starting point for hazard awareness for any property.
That My Hazards tool sounds incredibly useful for initial checks, quick and easy.
Yeah.
And you mentioned flood risk isn't just about coastal areas or big rivers.
Absolutely not. The Cal OES My Hazards source correctly points out that flood hazards exist everywhere, not just on the coast or major rivers. Any low-lying area or property near streams, even small, seemingly harmless ones, is potentially vulnerable to flooding. Floodplains exist in every state. Even desert areas can have flash floods.
Good point. Beyond floods, earthquakes are obviously a defining hazard for California. What's the main offense there?
They certainly are. California is highly seismically active. Our defense is largely built into the California Building Code, which establishes minimum standards for building design and construction, particularly concerning seismic safety.
So a building built to code is earthquake-proof, safe to be in.
And here is a vital nugget for client communication in California. No, that's a common misconception. The Seismic Safety Commission source makes this crystal clear. The California Building Code establishes a minimum standard designed for life safety. The primary goal is to design buildings so that they don't collapse and allow occupants time to safely evacuate during a major earthquake. It is not a guarantee that the building will be undamaged or even usable after a significant seismic event.
Wow, that's huge. So even a brand new building might be a teardown after a big quake, even if nobody got hurt.
It's possible. A building built to code or retrofitted might still sustain significant damage and be uninhabitable, but the design minimized the risk of collapse and loss of life. This is a critical distinction to convey to clients managing their expectations about risk.
That's a crucial point. Code compliance doesn't equal immunity from damage. What about landslide risks? Also a big issue in hilly areas.
Yes, especially after heavy rains or earthquakes. The California Geological Survey, CGS, is the key state agency for mapping and understanding landslide hazards. They produce various maps showing areas with landslide features and potential slope stability problems. Their mapping has been somewhat episodic, often spurred by major landslide events, unfortunately.
Are there different types of CGS landslide maps, and what do they tell us? Like, how likely is a slide?
Yes, and understanding the difference helps you interpret them. The conservation.ca.gov source describes them. There are landslide hazard maps, which look at where landslides might happen based on the ground conditions. Susceptibility maps just consider site properties like steep slopes or weak soil. Potential maps combine susceptibility with the likelihood of a trigger, like a storm or earthquake.
Okay, so potential means it has the right conditions and a likely trigger.
Right. Then there are landslide risk maps, which go further by estimating the expected losses to life and property if a landslide does occur in an area. That involves economics and population density. Finally, there are landslide zone maps. These are regulatory planning tools showing areas where California law mandates specific geological investigations before development can proceed because of the higher probability of landslides. These are often tied to the permitting process.
So susceptibility potential tells you if the site is likely to slide under certain conditions. Risk tells you the potential cost if it does, and zone tells you if the state requires extra reports just to build there.
Exactly. That's a great way to think about their practical use for you and your clients. The CGS also maintains a statewide database of digitized landslides online, which, combined with susceptibility maps, helps visualize where storm or earthquake-triggered landslides are most likely across the state.
Knowing about these natural hazards and having tools like FEMA maps, My Hazards, and CGS maps feels like a superpower for an agent, especially in California. It's part of the due diligence.
It absolutely is, and this is where you truly adapt and connect with your clients. Being able to pull up My Hazards during a showing to show a client the general hazard profile for an area, that's powerful. Or knowing where to direct them to find the specific FEMA flood zone or CGS landslide zone map for a property positions you as a knowledgeable, proactive advisor. You're not just selling them a house, you're helping them understand the inherent physical realities and potential risks of the land itself.
It helps them make informed decisions, anticipate things like mandatory flood insurance, or understand why extra reports may be required for development on a sloped lot. It builds trust and strengthens the client relationship.
Precisely. This knowledge is fundamental to competent and ethical practice here. You're guiding them through the whole picture.
Well, we've covered a vast amount of ground in this deep dive, tackling those hidden forces that shape our built world. It's a lot to take in.
It is. We've seen how planning and zoning lay the essential groundwork, from broad general plans and mandated preservation standards like Contra Costa's 6535 rule, to the specific details of subdivision regulations and the challenges of obtaining zoning variances.
We explored the government's powerful right of eminent domain, understanding its constitutional basis requiring just compensation for public use takings, and grappling with the complex gray area of regulatory takings and permit exactions requiring specific tests like nexus and proportionality. Those are key terms to remember.
We dove deep into California's Critical Environmental Statute, CEQA, outlining its informational purpose, the process involving initial studies, NDs, MNDs, and EIRs, and critically, highlighting how those exceptions to categorical exemptions can trigger review even for seemingly minor projects, using that HESCAG checklist as our guide. Don't forget those exceptions.
And finally, we navigated the inherent challenges of natural hazards in California floods, earthquakes, and landslides, identifying key tools like FEMA maps, the Cal OES My Hazards tool, and CGS maps, while understanding the crucial distinction between building code minimums for life safety and actual protection from damage. That's a conversation you need to have with clients.
Pulling back, it's clear that successfully navigating real estate in California demands a solid understanding of this intricate web of controls. It's fundamental to serving your clients ethically and effectively.
So here's a thought to leave you with as you continue your journey. Given all these layers of regulation, government powers, environmental considerations, and natural risks, what is the real estate agent's ultimate role? How do you, as an agent, balance your client's vision and aspirations for a property with the complex realities of the public good, environmental protection, and the inherent challenges nature presents?
It's about using this knowledge to guide them through that landscape with transparency and expertise, helping them make decisions that are not just personally beneficial, but also informed by these broader forces. Being that restorative guide we talked about earlier.
That's a powerful way to look at it. It's more than just finding a property. It's about navigating the rules that govern it, both man-made and natural.
Indeed. It's about competence and care.
That wraps up this deep dive into land use controls. Take some time to review those CEQA exceptions. They're tricky. Or pull up the Cal OES My Hazards tool and check out a property in your own neighborhood. Get familiar with it.
The more you explore these resources, the more confident you'll become in advising your clients.
Join us next time on the Deep Dive when we'll be unpacking the essentials of real estate contracts, another critical area.
Until then, keep learning.
And keep diving deep.